Hello. In today's episode, we're going to review the reasonable use of deadly force as constructed by the Supreme Court and the evolution of that legal theory from the mid-'80s to the present day. Full disclosure, I am an attorney, but I am not a criminal defense attorney. I don't practice criminal law. I'm not a state's prosecutor. I'm not a constitutional scholar. I don't practice constitutional law. So in this inquiry, I am but a layman who is fathoming the metes and bounds of this question, which currently confronts the nation in view of the shooting of Renee Good by Immigration's Customs Enforcement Officer Jonathan Ross in Minneapolis-St. Paul on January 7th. And this is rending the nation in two. On one hand, one side, you have the President of the United States, the Vice President of the United States, Stephen Miller, Kristi Noem, the Secretary of the Department of Homeland Security, all saying that the use of deadly force in that case was justified, that she had weaponized the car, and he felt threatened, and in the necessary defense of his person, he shot her. And then on the other side, of course, you have eyewitnesses on the ground. We have the video footage. We have the mayor of the city, the governor, even the state of Minnesota, all essentially claiming that the use of deadly force was not justified. I will say that these cases are highly fact-intensive, and I have no doubt that the estate of Renee Good will bring some wrongful death suit for, excessive use of deadly force, violation of the Fourth Amendment, violation of the Eighth Amendment, violation of the Sixth Amendment, so on and so forth. And during that case, the facts are going to be analyzed in ways that could bring this either way. I think, off the top of my head, from reviewing this, from reviewing the footage, from a legal standpoint, from reading the case law, I on the side that Agent Ross was not justified in using deadly force for a number of reasons that we'll get to. You can see my previous video, if you like, where I go through all of that. But really right here, we're just going to talk about the theory of when deadly force is reasonable and when it isn't, and the evolution of the concept. Originally, 18th century England, common law, 1736, a guy called Hale published basically this statement. He published this in the Pleas of the Crown, and he basically said, if persons that are pursued by these officers for felony or the just suspicion thereof shall not yield themselves to these officers, but shall either resist or fly before they are apprehended, or being apprehended shall rescue themselves and resist or fly, so that they cannot be otherwise apprehended, and are upon necessity slain therein, because they cannot be otherwise taken, it is no felony. So under the common law, felonious flight could be met with deadly force, and the killing was not of itself felonious. That's basically what that says. And of course, there has been kind of a history of like, hey, you fled, you broke the law, you're getting away, I can apprehend you, I'm going to kill you. And this happened in Tennessee in the 80s. There was a neighbor who reported seeing a burglar breaking into her neighbor's house. The police arrived in time to see the suspect exiting through the rear of the dwelling. He was at the end of the yard, about to climb over a fence, when the officer attempted to apprehend him from a distance and basically yelled, hey, stop, you're under arrest. The suspect continued to climb the fence. The officer shot him in the head. They found on his person $10. So they killed the guy over $10. He was also a small guy. He was slight, is the way the court describes him. And he was clearly posing no threat to the officer. The officer didn't even claim that he felt threatened by the fugitive. But he relied on a state law that basically says, similar to the common law, if you like, that if after notice of the intention to arrest the defendant, he either flee or forcibly resist, the officer may use all the necessary means to effect the arrest. All the necessary means to effect the arrest. That's the Tennessee Code 40-7-108, which the Supreme Court found unconstitutional for violating the Fourth Amendment, which we're going to get to. I would argue, of course, that shooting him isn't a necessary means to effect the arrest, but nonetheless, the district court found that his use of deadly force was reasonable. The Sixth Circuit Court of Appeals affirmed the reasonable use of deadly force in shooting this guy trying to escape by climbing the fence. The Supreme Court took certiorari 1985, pronounced the law unconstitutional. Basically, the court says that you cannot shoot a fleeing suspect when no imminent threat to the officer or others exists. They basically found that permitting officers to use deadly force to apprehend fleeing suspects, and I'm quoting here, has no impact on crime rates and does not improve the crime-fighting ability of law enforcement agencies. So I cite that just because a lot of people online have been saying, well, if you can shoot fleeing suspects, people wouldn't flee and they would comply with the law. They need to comply with the law. They're breaking the law by fleeing. So yeah, no, I've actually seen people making those comments, which, as I mentioned in a previous video, is what Chairman Mao said. He said that it's better to let 100 innocent people die than to let one guilty man go free. But again, it's alarming that people feel this. So this is kind of why I wanted to bring this up. Now, in going through kind of the dicta in explaining why deadly force was allowable under the common law versus it not really being allowable today to just shoot a fleeing suspect, the court touched upon the fact that common law felonies were of themselves capital offenses. Burglary, arson, rape, kidnapping, murder. These were offenses in the 18th century that were capital offenses. You would be killed if you were found guilty of them. So killing a fleeing felon was kind of commensurate with the penalty that they were facing. Robbing somebody of $10 probably shouldn't be a capital offense, right? Additionally, the court recognized the fact that the instrumentalities that police officers have at their disposal to apprehend a fleeing suspect have evolved. In the 18th century, they had clubs, right? They may have had a musket, I don't know, but they didn't have handguns, they didn't have tasers, right? So obviously the use of deadly force might arise more frequently when grappling the guy to the ground and engaging in some kind of hand-to-hand combat, as I would imagine frequently occurred in trying to apprehend a felon who's going to run because they don't have guns, right? They can maybe more easily escape. And then finally, the court also found that, of course, felonies have evolved. What is a felony today isn't necessarily a capital crime, and many misdemeanors actually become felonies by a threshold, sort of repeat offense, maybe the weight, right? A certain weight of a prohibited substance could be felonious, and a couple of grams less, and it's a misdemeanor. So the flight of a presumed felon by itself is not sufficient grounds to warrant deadly force. And so they concluded, and I quote, "We conclude that such force may not be used unless it is necessary to prevent the escape, and the officer has probable cause to believe that the suspect poses a significant threat or death of serious physical injury to the officer or others." Right? So hence all of the arguments about whether or not the car was a deadly weapon, whether or not the police officer felt threatened. So, okay, let's say that Agent Ross did feel threatened. If she was just fleeing, he didn't have the right to use deadly force. If, on the other hand, he felt threatened, could he have used deadly force? Well, under the Fourth Amendment, which is the test that we apply, we're looking at the reasonable use of deadly force. We construct the Fourth Amendment. The court has consistently found that the use of deadly force constitutes a seizure under the Fourth Amendment. Essentially, they seize your life. Any time that you are prevented from moving freely by law enforcement, you have been seized under the Fourth Amendment. The Fourth Amendment, of course, says that the people are free to be secure in their persons and their papers and their effects from unreasonable searches and seizures. There's the reasonable, right? So under the Fourth Amendment, the test for the reasonableness of deadly force was construed in a case called Graham versus Connor in 1989. And essentially, under that test, the test becomes an objective test. It's not a subjective state of mind of the officer at the time of the threat, if you will. It is an objective test of what a reasonable officer on the scene would have done in similar or the same circumstances. This is important because it also relies on the totality of the circumstances. That means what happened before the arrest, how the stop was initiated, what the officer knew about the suspect, as well as what happened afterwards. The Supreme Court specifically rejected the Fifth Circuit's moment of the threat rule, which asked only whether an officer was in danger at the moment of the threat that resulted in the use of deadly force. That wasn't until 2025. That was a recent case called Barnes versus Felix, and in that case, the Supreme Court specifically rejected the moment of the threat, which is how the Fifth Circuit constructed the moment of deciding whether or not deadly force was applicable, and was that reasonable only at the moment. And this case is kind of interesting because the police officer had pulled over a guy for violating tolls. He had not been paying at the toll, and he drove through. And the law officer ordered the suspect to exit the vehicle. He did actually roll down his window, and then he kind of changed his mind, and he began to drive. And so as the car began to move forward, the officer jumped onto its door sill and fired 2 shots inside. The suspect was killed, but he did manage to stop the car, and then he died, basically. He bled out. 2 seconds had passed since the officer jumped on the door sill of the car and the moment he fired his shot. So, how fast was he going in 2 seconds? We're going to get to that, actually, because that's an important question. But the point is that under the moment of the threat standard that the Fifth Circuit had adopted, it was reasonable for him to kill the suspect because he was on the door sill and the car was accelerating away and he feared for his life. He didn't want to jump off the car because it was already moving fast enough that he could be harmed, so he shot the driver to stop the car. Now, the district court found under that standard, the moment of the threat test, that yes, it was reasonable. The Fifth Circuit Court of Appeal ruling that if they weren't using the moment of the threat test, there might not have been reasonable use of force here, but under that test, which is the Fifth Circuit's test, it was reasonable. This is kind of the argument that is being made, that at the moment she put the car in drive, the Agent Ross was entitled to shoot her because he felt threatened. That's kind of a moment of the threat test, which in this case, the court found unconstitutional because it abrogates the totality of the circumstances that the Supreme Court already held in that Graham versus Connor case in 1985. Excuse me, 1989. So, importantly, the Supreme Court ruled that the totality of circumstances review under the Graham, reasonable officer standard has no time limit. The moment of the threat rule applied below prevents the sort of attention to context and thus conflicts with the court's instruction to analyze the totality of the circumstances, the court said. A court deciding a use of force case cannot review the totality of the circumstances if it is put on chronological blinders. Now, this is important because what constitutes the totality of circumstances are things like the severity of the crime prompting the stop. That can carry weight in the analysis. So, for example, in this case, the guy just hadn't paid a toll. Was it reasonable for the officer to shoot him over that? Was it reasonable for the officer to jump on the car? What impelled the stop to begin with that violated the Fourth Amendment, right? It arguably violated the Fourth Amendment. The actions the officer took during the stop, such as giving warnings or otherwise trying to control the encounter. In other words, did he tell him to stop? Stop thief, stop the car. Did he tell him, I will shoot, stop or I'll shoot? Those things factor into the analysis that the moment of the threat test avoids. Also, did the officer provoke the threat that he seeks to neutralize? That's an important question under the totality of the circumstances. And finally, of course, the stop person's conduct is always relevant because it indicates the nature and level of the threat posed, basically to the officer or to others. So basically, in this case, toll avoidance is hardly a severe crime. Under the moment of the threat, the officer was threatened objectively to jump off the car, killing the guy might have been reasonable under the reasonable officer standard. If another officer was riding on the side of the car, he had to stop the car, that might have been reasonable. Under a totality of the circumstances, it's not reasonable. We have to look at the totality of the circumstances. So let's jump into the imminent threat. What constitutes an imminent threat? And we have a couple of good cases here that involve cars and officers shooting the drivers of the cars. Not just that Bayo versus Felix case that I mentioned, that I think is in a way applicable. We have another one where 3 officers shot a guy, again, over really nothing other than the fact that he tried to flee. And in this case, an officer jumped in front of the car, kind of like in the Renee Good shooting, and shot the driver. And then the 2 other guys shot the driver as well. And whether or not they had qualified immunity, and whether or not, that this was a reasonable use of deadly force, came into issue. It went all the way back up to the Supreme Court. And they basically said they need to review it under these assumptions, because whether or not he put himself in front of the car and created the threat was something the court needed to analyze. Whether or not he jumped in front of the car and the driver didn't have time to slam on the brakes and therefore wasn't intentionally trying to run him over needed to be analyzed under the circumstances. And finally, the underlying crime. The defendants knew that the underlying crime was not accomplished violently. They also knew that Starks was attempting to escape in the face of a clear show of authority by the police. But his escape attempt did not involve menacing a police officer or civilian with a weapon. At least not until Black stepped into the path of a car that had just begun to accelerate quickly. That's the court construing the facts in a manner that the police officer put himself in the danger. His attempt to maneuver the cab, that's what happened. He stole a cab. This guy stole a cab, and he was parked, and the cops found him. I think they're outside of a restaurant, and this sort of brief little moment ensued where they tried to arrest him. They knocked on the window, and he just said, "No, I'm out of here." And then this whole thing happened. He reversed. He went forward, he reversed, he went forward, he reversed, and he tries to go around. And as he tries to go around, and this is why I think the facts are somewhat similar, this police officer tries to jump in front of the car and just shoots him. And he was behind a light pole. So we got a light pole on one side of the cab. We got the officers here. There's a guy coming around the light pole, kind of like in the Renee Good case. And he's trying to reverse to avoid the light pole and get away and around between the cars and out, and the guy jumps out. So his attempt to maneuver the cab, this is the Supreme Court, was not so reckless that, apart from Officer Black's appearance at the front of the cab, police officers could reasonably fear for their safety or the safety of the community. Therefore, it cannot be concluded that a reasonable officer could believe that the driver, in this case, fit the description of a fleeing felon against whom deadly force could legitimately be used. This case, by the way, is called a State of Starks versus Enyart. It's not the Supreme Court. It's the Seventh Circuit. But it was cited, this case, by the Supreme Court in some of the cases that I reviewed constructing this issue. So I want to point out here that in that State of Starks versus Enyart, where they basically found that the police officer kind of contributed to the threat, if you like, and put himself in harm's way and then sort of tried to neutralize the threat that, in a sense, he had created, and that, therefore, it's not necessarily willful volition on the part of the driver to try to hit the officer, and it was more akin to, an accident where the driver is knocked off course and he doesn't have control over the fact that he's going to hit this officer. So was he really threatening him or not? The Ninth Circuit used to have a test that they would apply in these cases that was basically called the provocation rule. And that was, firstly, they'd analyze everything that I've just said, but then they'd also analyze if another Fourth Amendment violation had occurred during kind of an escalating encounter with the police in a manner that the police were essentially escalating and provoking the conduct, then basically that could be a second theory by which to assess damages against the officers, independent of whether or not the actual use of deadly force was reasonable. Now, the Supreme Court expressly found the provocation rule also unconstitutional. And that was quite recently that case was resolved as well. So the provocation rule, as employed by the Ninth Circuit, no longer applies in the analysis of the reasonable use of deadly force. And simply because I believe it's been subsumed in that totality of the circumstances, right? The provocation, the role that the officers played in basically confronting and stopping and, violating the Fourth Amendment and seizing the individual in question, plays into the totality of the circumstances and the overall reasonability of the use of deadly force. Let's see, is there anything else I want to say? So, what are the key points likely to be in the lawsuits that are coming? No doubt. First, Ross's interaction with Good. We see him walk around the car. She seems quite cheerful. She doesn't seem to be threatening. Now, some people have argued that she's playing rope-a-dope, was, I think, the meme that I saw, or the post that I saw, that she was basically ice-cold, premeditating her murder, and she was pretending to be nice. I don't get that sense at all, and I'm not sure a jury would either. But Ross's interaction with Good, when he walks around the rear of the vehicle, is going to factor into this. Good's waving them on to go by is going to factor into this. Good's statement that she's not mad at them is going to factor into this. The fact that she had been on the scene before, allegedly, and was interfering with ICE operations is going to factor into this. The fact that she was a member of some alleged agitating group that taught protesters how to interrupt, and obstruct ICE operations probably won't factor into it, because I don't think that Agent Ross would have been aware of that, or anyone on the scene was aware of that until after the fact. But, it kind of goes both ways. I think it's sort of like, on the one side, if she was showing up repeatedly and obstructing ICE operations, that shows that she has the intent to sort of be in the way and kind of, I wouldn't say malice, but to be something of a bit of a menace. But I think it weighs more favorably on her side, because she just didn't really seem threatening, and she didn't seem like a dangerous felon. The crime that she was committing that initiated the stop and the seizure, where the agents ran up to a car, the one guy put his arm into the window, it wasn't a violent crime. So that's very strongly in her favor. So the reasonableness of the initiating arrest, okay, they definitely had a reason to do it. They had a reasonable suspicion that she was obstructing their investigation. They had probable cause to detain her for obstructing their investigation, potentially, if they couldn't drive around, or I'm not sure about the totality of the circumstances there. That's one of the fact issues that's going to be, I think, litigated pretty heavily. But on the whole, it was a slight crime that definitely didn't suggest she was a violent felon. Other things that are going to be very important, the speed of the vehicle. So it's certainly true that a Honda Pilot, which I think is what she was driving, can accelerate within a couple of seconds to, 30 miles an hour. That's enough to kill somebody, right? 2 to 3 seconds, hitting 30, 35 miles an hour. That's doable if you punch the accelerator, as has been alleged by the likes of the Department of Homeland Security and others. But watching the video, I think I timed about 1 second, 1.5 from her rocking the car forward and him shooting her. And in that 1.5, maybe 2 seconds, it's clear that she doesn't spin the wheels. There's no smoke that comes out. She's not accelerating at the full performance of the vehicle, and she's definitely turning. So that speed, which I think will be measurable, it'll be measurable by the agent who's got his arm in the door, who is actually walking alongside before the car turns away after the first shot is fired. She's clearly, in my estimate, not going more than 3 miles an hour. That's going to be an important fact, because I don't think that creates an imminent threat, as well as the fact that the officer could move out of the way of the vehicle, as my other video has already done. And if you're interested in that, watch that video. I go into a full depth analysis about where the law is on including, whether or not there are reasonable, safer alternatives to the use of deadly force, including moving out of the path of the vehicle. So the last point, of course, is he shot multiple times. The first time, the car was probably going, as I said, about maybe 3 miles an hour. And the second and third times, he was clear. He was clear of the vehicle. So basically, at the end of the day, I think the estate of Renee Good has a really strong case. And I think at the end of the day, Agent Ross is probably going to have to plead negligent homicide or or something. I don't know if they will get criminal charges against him because it's unclear if the federal government is going to prosecute him. But I think under that section, is it 1853? I forget what it is. But under sort of a wrongful death claim or the violations of the 4th, 5th, 8th, even the 6th Amendment, they have a pretty strong case. So, yeah, there you have it. Thanks for listening.